representation or application of international conventions, and not to act as a court of criminal appeal, end of quote. This principle was also reiterated in Avena and Legrand. It bears repetition that where the national of another state is accused of acts of terrorism, and which, if established, carry the sanction of capital punishment, and the trial is by a military court, the need for consular access and the opportunity to arrange for legal representation in the course of the trial, as covenanted in the Vienna Convention, is all the more greater. An Indian national was in military custody. He was made to confess, and then he was tried for offenses and awarded death penalty. The prejudice caused by egregious breach of the Vienna Convention assurances provided for in Article 36 is writ large and does not merit any further elaboration. India asserts that the breach of the Vienna Convention in the facts of the present case is fatal to the trial of Jadhav. In its communication of 12th of May, Pakistan states that it, and I quote, rejects the contents of the request and of the application as providing any basis for this court to exercise jurisdiction, whether by way of preliminary measures, relief, or otherwise, end of quote. India bases its application on the jurisdiction of the court conferred by Article 36, paragraph 1 of the statute of the court, and Article 1 of the optional protocol concerning the compulsory settlement of disputes 1963. The binary conditions by the optional protocol are satisfied. That being so, this court would have jurisdiction under Article 36(1) of the statute, paragraph 1 of the statute of this court. India has thus provided, I submit, sufficient basis for this court to come to the conclusion, definitely prima facie, that it has jurisdiction. I now move, sir, to addressing you on the jurisdiction of this court under Article 36, paragraph 1. The compulsory jurisdiction of this court under Article 36, paragraph 1 has three dimensions. Jurisdiction exists, A, in respect of all cases which parties refer to it, B, in respect of all matters specially provided for in the Charter of the United Nations, or C, in respect of all matters specially provided for in treaties and conventions in force. The optional protocol specially provides for resolution of disputes relating to the Vienna Convention. Its language is mandatory. It provides that all disputes arising out of the interpretation or application of the Convention, and I quote, shall lie within the compulsory jurisdiction of the International Court of Justice, end of quote. Article 36, paragraph 2 of the statute deals with a declaration by party states of the recognition, and I quote, as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation, end of quote. India does not seek to assert jurisdiction for its application in paragraph 2 of Article 36 of the statute. Any reservations made in the declaration made under Article 36, paragraph 2 are irrelevant for the present case. The construction of Article 36 is no longer res integra. The fact that this court may have more than one jurisdictional basis is now well recognized, and where there is a multiplicity of agreements, it evidences that, and I quote, contracting parties intended to open up new ways of access to the court rather than to close old ways or allow them to cancel each other, end of quote. The general principle where the court has jurisdiction based on both optional declarations and compulsory jurisdiction clauses in treaties is that each title is autonomous and ranks equally with the others. The commentary in Robert Kolb's book is illuminating. It says, and I quote, where there are several concurrent titles of jurisdiction, they do not cramp or limit each other's effects. On the contrary, they complement and reinforce each other on a cumulative basis, end of quote. It says that the reservations in one title of jurisdiction cannot be transposed into the other. The argument that, and I quote, the title of jurisdiction resulting from optional declarations has a higher value in the hierarchy than one deriving from a treaty must be rejected, end of quote. The commentary tells us that titles of jurisdiction remain in existence until either modified or terminated, and it cannot be argued that, and I quote, a more restrictive subsequent optional declaration is evidence of the state's will to submit to the court's jurisdiction in a more limited way, so that a prior and a more widely worded compromissory clause must be considered to have undergone a kind of derogation, or vice versa. It is for the parties themselves to choose the titles of jurisdiction they intend to rely on. End of quotation. Mr. President and esteemed members of the court, India relies on the Vienna Convention, the optional protocol, and Article 36, paragraph 1. The jurisprudence of this court also concludes this issue. In the Electricity Company of Sofia and Bulgaria case, the Belgian government relied on declarations of Belgium and Bulgaria accepting the compulsory jurisdiction of the court, and also on the treaties of conciliation, arbitration, and judicial settlement entered into between Belgium and Bulgaria on 23 June 1931. The Bulgarian government challenged the jurisdiction of the court. It was in this case that the court held that, and I quote, multiplicity of agreements concluded accepting compulsory jurisdiction as evidence that contracting parties intended to open up new ways to access the court rather than to close old ways or allow them to cancel each other out, with the ultimate result that no jurisdiction would remain, end of quote. In Nicaragua and Honduras, Nicaragua instituted proceedings in respect of a dispute concerning the alleged activities of armed bands said to be operating from Honduras. It founded the jurisdiction of the court on the American Treaty on Pacific Settlement, known as the Pact of Bogota, and also the declarations of the two parties. Honduras resisted jurisdiction on the ground that the dispute was excluded by terms of the Honduran Declaration of 22nd May 1986 and claimed that the declaration would apply to the Pact of Bogota. Honduras relied on the language of Article 31 of the Pact, which opened with the words, and I quote because they are important, in conformity with Article 36, paragraph 2 of the Statute of the International Court of Justice, unquote. Mr. President and esteemed members of the court, you will find no such words are to be found in the optional protocol. In the Honduras case, on the basis of those words, Honduras argued that the declaration made by it under Article 36, paragraph 2 of the statute delineated the extent of jurisdiction even under Article 31 of the Pact. This argument was rejected by the court, finding the language of Article 31 made it clear that it did not subject itself to the making of any new declarations to be deposited under Article 36, paragraphs 2 and 4 of the statute. The court observed in paragraph 33, turning to the Honduran interpretation, and I quote, the court may observe at the outset that two possible readings of the relationship between Article 31 of the statute